Well, welcome everyone, and we're delighted to have you join us in this workshop on strategic intellectual property and privacy planning for AI. My name is Curtis Behmann. I'm joined by my colleagues Carina, Pellegrin, and Max Jarvie. We're BLG, Borden, Ladner, Gervais. We're the largest law firm in Canada, really focused on innovation and working with innovative companies like those who work in the AI space. So I thought we'd start off with just thinking about why should a company who works in AI even bother with intellectual property? And so we'll look at a couple of examples here. One is a company that had a key employee walk out the door with company trade secrets on a USB drive. It could have completely destroyed the company. It didn't, but they had to pay about $100,000 in forensics and other fees to fix the problem. And it could have been totally avoided if they had a proper trade secret protection program in place. We had another client in the software space who was getting noticed by some larger players. As part of an IP audit, we determined that they should file some patent applications. We helped them file a couple of provisional patent applications at a modest fee, and they were eventually acquired. And during the acquisition, the patent applications were found to have contributed $100,000 to that purchase price. And then another client at a different end of the scale had a patent portfolio, and they invested about $2 million in enforcing that patent, and they eventually received a $700 million judgment. And so regardless of whether you have your philosophical leanings on patents or intellectual property, you can't argue with a return on investment like that. And then if we look at published papers in the AI space from the 2011 to 2019, there was a 25% increase in published papers. And in that same time frame, there was a 625% increase in the number of patent applications. So definitely many companies are finding this to be an important part of their strategy. And in this data and other data, we're stopping at 2019 just because it's the last year for which we have complete data on all the published applications. So one tip in terms of an IP strategy, and so you may have heard in some other sessions that a lot of companies are trying to develop an AI strategy, and some of you might be helping others to do that. And so similarly, you're going to want to look at developing an IP strategy. And the first tip is to have a holistic portfolio-based approach. So IP is really a set of business tools that help you get a tangible benefit from intangible assets. And so one of the main reasons is to attract investment and partnerships and to show leadership. Some of the tools in that toolbox will be industrial designs, patents, and trademarks. And those are assets that need to be filed in an IP office to get protection. Industrial designs protect the aesthetic appearance of a finished article, or electronic icons or graphical user interfaces. Patents protect new and useful inventions. It could be software, it could be a device. It doesn't allow you to practice the invention, but it does allow you to exclude others from practicing the invention. Trademarks usually protect a word or a logo that identifies the source of a finished article, like the Nike shoe here. Copyright, you can have protection without filing, but you can get enhanced protection with filing. And that, from a software perspective, protects the code, so the actual expression in that finished work. So if someone wrote different code to achieve the same result, the copyright protection wouldn't do anything in that case. Social media handles, website URLs, all different types of IP, as well as trade secrets that Carina will be speaking about in a few minutes. One practical tip, if you haven't decided what to do on IP protection, don't disclose that subject matter, especially if it's part of your secret sauce. That disclosure could prevent you from getting any protection, and it's an easy thing to just avoid the disclosure until you've decided what to do with IP protection. The second tip in terms of AI IP strategy is to leverage data and to be strategic. So there's a lot of data out there, and one of the things is we can figure out what are companies patenting relating to AI. This can help you know if you have freedom to operate, so whether someone could assert their patents against you and prevent you from continuing in your business, or give you competitive intelligence on what others are doing. So here, this chart shows some of the top key technologies by patent classification in terms of AI patenting worldwide. So some of these you might expect, like the salmon color at the bottom, machine learning, you have 4,800, almost 900 patents. One of the ones that surprised me a bit was the second one, the kind of turquoise color, computer systems based on biological models. I wouldn't have thought that that's the second most common key technology by patent classification at almost 9,000 patents. Similarly, if you look at keywords, it's another way to slice it. Some of the things you would expect, neural networks, machine learning, maybe control methods for autonomous vehicles and vehicle control, but then a lot on communication systems and electronic devices and some other aspects as well. Then we can look at who is patenting in AI. So this can again give competitive intelligence and help with identifying white space, either from an IP perspective or from a business strategy perspective, or both. So you can see here that there's a difference when you're looking either worldwide or US only. There are 6 of the top 10 here are in both, the ones that are in bold. In the 4 others that are in the worldwide are all based in China, and there a lot of the filings, especially the Tencent, are massive compared to some of the US only ones, but they're not filing in the US. Similarly, some of the top 10 in the US are not filing that much outside of the US. You can also see, if you don't have a large portfolio, who are the new entrants in terms of AI patenting. So you might recognize some of the names here, some of them might be new, and this could be a way to recognize up and coming companies in areas that might affect you. You can see here only one company, Capital One Services, is in both. And interestingly to me, in the worldwide, there's this Ping An, which is an insurance and technology company in China. They actually have 3 of those top 10 entities. And the one at the bottom of that chart there has by far the most out of any of them. So that's what people are filing, but what areas are being litigated? So you can see from this chart that these tend to be some of the AI technologies that are more mature. So you can see kind of home management, concierge devices, energy use. So you can think maybe of the smart thermostats or things like that, where the patents are a little older and they're looking to monetize those compared to the different profile of the ones that have been filed more recently. And then to take things to the next level, you really want to have a holistic approach that's aligned with your business goals. And BLG recently launched under our BLG Beyond banner, our Beyond IP strategy offerings. And so we have different IP strategy programs that really help you to grow and protect your market position and have a business-focused strategy to help you be more intentional about what you do or don't do from an IP perspective. So we'll look at a couple of the buckets that we operate in. So this can help you maybe identify 1 or 2 key aspects that maybe you should be focusing on in the short term. So strategy programs, there are some specific programs that have been built. We have under our Growth Catalyst program for startup companies, for companies that are in a growth stage or an earlier stage, to figure out either what role IP should play in their business, or to figure out how do we execute and how do we plan and do this. We can also help in terms of a trade secret protection program to avoid the issue that was identified earlier. In terms of bespoke advisory, this could be anything from establishing an invention review committee within your company, figuring out how do you navigate open source, or if you have a competitor that has a lot of IP, how can you navigate that? It's been said that culture eats strategy for breakfast, and so building a culture of IP in your organization that reflects the IP strategy that you want to convey is part of that education and awareness that can really be strategic and important. The insights that you've seen in some of the charts and the graphs can really help you to know what competitors are doing and help inform what your strategy will be, or at least just keep an eye on key competitors and new entrants. And then deal readiness, whether you're preparing for financing or an acquisition or an exit or even partnership discussions, you want to really get your IP house in order before you start those discussions so that you can maximize the benefit of those negotiations. And so I'll just flash up on the screen here some of those things that we've just talked about. And if you see 1 or 2 here that really resonate with you, I'd encourage you to look into it further. Feel free to reach out, and maybe that would be kind of the next step in your focusing on IP strategy for an AI company. So now I'm going to turn it over to Carina and the next part of the presentation.
Yes, hello. I'm Carina. I am a computer engineer and lawyer and litigator at BLG, and I'm just going to take up where Curtis left off and talk a little bit more about patenting, trade secrets, and some contracting issues. So Curtis talked about patenting, and the question we want you to consider is your business leaving money on the table, or will they be leaving money on the table? Patents can protect certain aspects of your AI business, system, or product, and this can be a very valuable asset, especially in the expanding market, as we have seen from Curtis's slides. The decision to do a robust IP analysis is part of a good business planning. So the question is, what is an invention? What can we patent? What is an invention? As Curtis mentioned, an invention is something that is new, meaning it hasn't been previously disclosed. It's useful in some way, and it's not simply obvious. There's an inventive step that's happened. When we talk about AI inventions, they are computer implemented inventions typically, and there are hurdles for those types of inventions in patent law, because things like computer programs or an algorithm per se are not considered patentable in many jurisdictions. There needs to be something more. These are just a few examples of various ways it is looked at in various jurisdictions in Europe and in Canada and in the US. There is a misconception, therefore, because of these hurdles, that AI is software, AI is not patentable, we're not even going to think much about this because we just can't get protection, or everything is changing so fast that it's not worth the investment in patenting. So that may be true in some cases. It's not true in a lot of other cases. And the point that we would like you to take home is that there are many aspects of an AI system that can be patented in a number of jurisdictions. Things like a novel method for making and training your AI model, or the trained model itself, various aspects of it. Often there needs to be some technical aspect to what you're claiming so that it's rooted in the technology, so that it's not just an algorithm per se. You can also even protect, in some cases, the output of your AI model, such as a new drug that's been discovered by your AI, or a new design of a product. Lots of different areas, but this is just two examples of two patents that have been issued for AI-related inventions, and it's interesting to see the type of language that's used. So as Curtis mentioned, it's a business analysis. There are a number of things to consider. If you're looking at developing a more robust IP strategy using concepts of trade secret law, patent law, and those types of considerations. This just shows some of the considerations: your ability to generate revenue, other people's ability to reverse engineer your product, your phase in the development, and of course there are many other market considerations. But the point is, it's something that needs to be approached carefully and diligently. A little bit about trade secrets. So there's, again, some misunderstanding about trade secret law. I think that many companies believe that that a trade secret is a trade secret, and that is, it can be the case, but there are very specific legal requirements that you need to meet in order to show that you have protected or that you've kept a certain aspect of your technology as a trade secret in order to be able to get protection you also have to be able to show that there's a specific commercial value associated with that portion of your technology. And these are a number of different types of things that you need to think about and put in place in order to benefit from trade secret protection in law. With trade secrets, if the secret is made public, it is no longer a trade secret. Therefore, that is something to consider as well. So this is a bit of a slide that has a lot of information on it, but it's basically comparing patenting versus trade secrets. And it's probably good to think about the fact that in a lot of cases, it's not all or nothing, it's a little bit of both. There can be aspects of your technology that you attempt to patent and keep as patent numbers in different jurisdictions, and there can be aspects of your technology that you try to keep secret as a trade secret. But there are pros and cons of each approach that need to be carefully thought about. For instance, patents, with a patent, you can prevent others from copying your invention for up to 20 years from the time that you filed. A patent or provisional or patent application can, as Curtis was mentioning, can generate value for M&A purposes. It can be monetized in various ways. You can license your IP technology. You can sell your IP. You can sell your IP with your company. It's a more concrete way of showing that there's value in your product, in your technology, and what you're doing. However, if your invention is disclosed publicly before patents are filed, then you cannot get a patent. Also, freedom to operate. If a patent will allow you a certain amount of freedom to operate in your area, because if somebody else patents your technology before you do, they may prevent you from using your own technology. But there are costs, of course, to patents. Keeping them alive. Patents need to be filed in every jurisdiction where you intend to do business or want to protect those rights. But it can be effective in the long run, although it can be expensive at the outset. So the takeaway is think about formalizing and documenting your innovation process internally. Having a formalized process where any potential ideas and innovations are discussed, reviewed, formalized can add tremendous value and show that your company has a robust IP strategy. These are the types of things that you would do with a formalized innovation process. And the bonus at the end would be that if you do go ahead with writing patent applications, you've already gathered all of the information or a lot of the information you would need to give to a patent agent in order to draft your patents, and it can reduce your costs going forward. Similarly, formalize and document your company's trade secret policies. This doesn't need to be overly complicated. It can be done even if you're a small company. Mainly, you want to clarify what it is exactly that is considered to be a trade secret, what you're protecting, and how you're doing it, so that it's very clear and you can prove it later in court if you have to. So in the context of trade secrets and patenting, it becomes clear why things like confidentiality clauses or agreements and non-disclosure agreements need to be properly written and in place at the right time so that patent secrets aren't disclosed before you file your patents, and so that trade secrets aren't disclosed, making them no longer of any value as a trade secret. So these clauses or agreements should be in place with your employees, with independent contractors, anybody who comes into contact with your confidential information. They can be included as clauses in employment agreements. All company information should be deemed confidential, and these agreements should be clear about no public disclosures. When you're dealing with R&D partners, potential business partners, disclosures in the context of M&A, non-disclosure agreements are really key in order to have them in place before any confidential information is exchanged. Another issue to be included in employment agreements is the idea of inventorship and who is the owner of the patent, because often the employees are the ones inventing, but they are not the ones who will be owning the patent rights in the future. So these are elements to include in your employment contracts. And a takeaway is that all of your employment contracts should be reviewed in this context. It's important for due diligence. If you're in the middle of a deal and find out that you actually don't own the patents that you are selling, it's not very beneficial for your deal. So I will skip over this. This relates to whether AI can be an inventor itself. Just a quick word on data sets. There are two aspects when we're talking about data sets and AI systems. You need to be considering whether you have the right to use the data in two ways. You have to consider from an ownership perspective and what you have the rights to do with the data, and also from a privacy law perspective. And those two things can overlap, but there are very different considerations. Max will be talking about privacy in a moment. And I just wanted you to reflect on whether going forward your data agreements are in place to allow you to use the data in the way that you intend to use it in the future, and also the way that you are using it currently. What rights did you need exactly? Do you have permission to use the data for training your AI? Do you have permission to use the data in the final product? Is data supposed to be anonymized? Are there any limits? These types of considerations need to be carefully reviewed. Data sets can be protected by copyright. I'll just move by this quickly as I'm running out of time, but you need to consider whether you're licensed, what you can do with aggregated data. If you're selling data to a third party, you want to restrict what they can do with that data so that you can maximize its value. You want to consider whether any research that you're doing is an exception to fair dealing, a fair dealing exception to copyright. And then a little bit about branding. By 2024, the worldwide revenues from AI in terms of the market is expected to reach about 500 billion. Hugely competitive. Branding is hugely important. Your brand can become a very valuable asset for you. Unfortunately, when companies are starting up, the branding is sometimes a bit of an afterthought. And this is just a reminder that, especially in this market, your brand can be crucial, and you want to think about your brand repeatedly as you're going forward, but you need to think about all your major future markets. You need to do your trademark searches early. You need to do your trademark searches in the countries where you will be doing business. You need to seek out distinctive marks and marks that can be flexible and apply to different goods and services you may be offering in the future. Smart marks, AI marks are not particularly distinctive, so you want to be thinking about early on establishing marks that are surprising, memorable, flexible, so that you can invest in your brand from the beginning and not have to rebrand or have multiple brands in various jurisdictions, as that is pretty costly. So now I'm going to pass our presentation on to Max, and he will talk about privacy.